The case, my Lord, was adjourned till today for cross-examination of the witness. My Lord, the witness is in court and is ready for cross-examination. Most of them. Red barrel. Please, can you remind the witness that he is still on oath? Okay. Yes.
My Lord, we're prepared for cross-examination. I just thought, after an observation, I thought to bring it to the attention of the Lordship. Indeed, he had mentioned this to the claimant's counsel. The fact that the amended and claim was filed out of time and they need to put it in. We're prepared to proceed, but just to tell them so that they can file the appropriate application for extension of time before the next adjournment.
You said they did what? They amended their claim?
They amended this of someone and taking of claim was filed out of time. And I believe that my young friend had actually mentioned it, that she had mentioned it to counsel for 2 months in previous proceedings. They had undertaken to file an application for extension of time, but they didn't do it. However, so that we don't today's proceedings are not further prepared to proceed, but just so that they can bring the proper application before the next adjournment.
I think they filed that application.
Okay, one step, and they confirmed that they didn't have one, actually. One step with that application. And they did say that
there's an application here for an order granting gift to the claimant applicant to amend a read of summons and other originating process.
I'm looking for extension of time while they are making. Was it not filed within time? My Lord, I'm just checking the file, but what I want to say is I am aware of the fact that the defendant has responded to that process. So if, my Lord, we are ready to regularize, but there's the issue of law. If there's an irregularity and the party on the other side has taken steps, it becomes another issue. What is the extent and the effect of the irregularity?
Yeah.
You cannot take a step and you come and say there's an irregularity. You cannot approbate and reprobate. But it's not an issue of approbating and reprobating. No, have you? So that they can do the needful. Where be proactive so that there's no delay. A party can file a response to pleading where the other party, hoping that the other party will regularize and it will be doing proper on the same day. Even at the court of appeal. I don't have to proceed. I decide to proceed with this. We need to the question of the court.
If you have already taken steps, as the court says, as the rule, yes, the rule is if you have already taken steps, you cannot complain later. As the court pleases.
No, I told them before today. I told them before.
But have you taken steps? As the court pleases.
File an amended defense
in compliance with
Fine. You see, if you wanted this objection should have been raised very timeously.
as the court.
Yes, what do you lose? You have already responded to it. There's no miscarriage of justice.
I'm not very prepared to proceed to trial. It's just if they are comfortable with proceeding with a change that is out of time. We are guided that is false.
You have already taken steps.
Yes, because my lord, the rules are clear.
Yes, I am aware of it.
The rules are clear. Effect of non-compliance. You have taken steps.
Yeah. As the call places, I'm here. I didn't get that.
I said I don't remember. You're still under hold.
Yes, please. I'm still under hold.
Yes. Yes, the defense counsel.
Many of you request good afternoon.
Good afternoon.
I just want to confirm that you can say.
Okay.
Can you please confirm? Can you hear me?
I can hear you.
Yes. Can you please confirm the number of years spent in the employment of defendant?
I think it was about a
Hold
year.
on. Witness,
Yes, sir.
when the question is asked, I need to take the questions before I ask you to
As the court
respond.
pleases.
So when I tell you to respond before you start talking, so that I can record you.
As the court pleases.
As the call places, sir.
Yes. What is your answer?
1 year from November 2006 to November 2007.
Yes, counsel, go ahead.
And do you recall executing a contract of employment?
Please come again. I didn't get that question.
Do you recall executing a contract of employment?
Yes, I did.
Yes.
Now, in that contract of employment, and your document, your speed of your first document. In that contract of employment,
exhibit is that?
Exhibit W1, my lord.
Yes.
In your contract of employment, Exhibit W1, it was stated there that you would read and sign a copy of the confidentiality agreement of the defendant.
Yes, what is the answer?
Yes, it was there.
Yes, counsel.
Do you remember signing a copy of this confidentiality agreement?
Yes, what's the answer?
I think so.
Neither recall or don't. Do you recall signing confidentiality agreement?
That's about 18 years ago. I think so. I think I signed it.
Yes, counsel.
If I send you a copy of the confidentiality agreement, are you able to identify the signatures?
I'll try.
How do you do that? How would the witness be able to see the document?
You need to show that one page. One page.
I don't think I'll be able to.
Witness be able to see this?
No, sir.
You had the caption, you don't have the caption that says confidentiality. Sorry, confidentiality agreement. That's the caption. It's showing on my screen.
Can you see that?
I can see the heading confidentiality agreement, but I can't make out the words under.
Can you show her the second page that bears her name and
Have you seen that?
Yes, that looks like my handwriting and signature.
I know that's that.
Hold on. Yes, Mr. Babaka, any objection?
Sorry, I've not seen. My Lord, I have a problem with it. My Lord, the documents talk to the sender, secondary evidence. It's not primary evidence. And it's a copy of the confidential agreement. It's not the original, and no foundation has been laid for it. That's my objection. The rules of court must be observed. So I'm saying, my Lord, that there is no foundation for this document.
No, but there was notice to produce given to you.
My Lord, it is inferred that there was notice. There was no notice. The reference has to be made to the notice to produce. That's the foundation which has to be laid. So, my Lord,
the witness is not disputing that document.
I know the issue is not whether the witness is disputing the document, but the issue is the foundation, the evidential foundation of the document. If it is secondary evidence, not primary evidence. So primary evidence, secondary evidence can only be given when primary evidence, the foundation has been laid for it.
But let us say that document itself, yes, the document you're holding,
yes,
is in the custody of the witness.
My Lord, that foundation is not before the court. It's not before it is the court that is assuming that it's in the custody of the witness. The foundation was not laid. My Lord, that's what I'm saying, my Lord. Because that was the document, my Lord, it is contestable that the document is with the witness because it is the document of the defendant. The defendant secured the signature of the claimant, but it doesn't mean that the claimant has the custody of the document. The document is actually in the custody of the defendant because it's their agreement. So my Lord, that foundation is not, that evidence is not before the court, and that's the foundation which is necessary for secondary evidence to be admissible. They are in custody of the original. It's their document. And they have not told the court where the original is. So, my Lord, we cannot close our eyes to the rules and they just bring in anything. It's not, that's my submission.
Yes, yeah.
My Lord, indeed, we had issued a notice in respect of this document, and the claimant did not say that the document was not in their possession. However, my Lord stated
where did you, how did you the notice to court assist?
But I'm trying to find the document that has the notice to fulfill. However, my
Lord, if I might assist court, I need to read paragraph 6 of their amended statement of defense, where reference to the confidentiality agreement is made. It says further to the...
Just a minute.
I'm sorry.
Now, further with the witness, the position you're talking about is the one that accompanied the originating process, no?
I'm sorry, man. That question to me?
Yes, yes.
I'm talking about the amended statement of defense.
Okay.
Amended statement, which was, my Lord, the step taken in response to our amendment. The amended statement of defense was filed in this court on the, I think, 15th May 2012, or the 16th May 2019. The document received by this court on the 16th of May. Not sure I can see the thing very well.
Okay, amended statement of defense.
16 May 20. Yes. So I'm referring to that document, the record of this court.
Paragraph what?
My Lord, I must apply. Paragraph 6, paragraph 10, paragraph 11, paragraph 12, and paragraph 14. I would even go further to say paragraph 15, 16, 17. Still talk about the confidentiality agreement. My Lord, I'm sorry, man. I'll wait for my Lord. I'm sorry, my Lord. Well, I'm sorry.
Yes.
Okay, my Lord, my submission is that in all those paragraphs where reference is made to confidentiality agreement, that they obtain a confidentiality agreement from the claimant. There is no evidence there, and there's no implication there, and it cannot even be inferred that the original is with the claimant, because, my Lord, for me, it is a condition of their service that they must have the signature of the claimant. So there's no evidence here that the document was left with the claimant. I'm relying on their pleadings. So it cannot be presumed that the document is with the claimant, because it's a document introduced by the defendant and meant for the defendant's protection. So the original cannot be deemed to have been with the claimant. It's clear from the pleadings, and there's nowhere that they have stated that the notice to produce is being served on the defendant. So we are saying, my Lord, that the conditions of the evidence must be clear. You cannot just tell that the document which you have the custody of the original, and you take the photocopy and bring it.
Yes, yeah.
Why not? Given the fact that it's a defendant's document, I'll put an defendant's document. I just want to have to identify the fact that and the fact sign the confidentiality agreement, which I said is on. So whether I said that the document is coming or not, I will not for now. I will tell her it at a later time.
My Lord, with due respect, I submit that the proceedings of this court cannot be put front or back. You cannot apply to tender a document and you are recorded as wanting to tender the document. And we have brought an objection to it. There must be a ruling on it. Cannot withdraw my objection. Cannot withdraw the fact that I wanted to tender it. The records of the court will not be clear. We cannot do ding dong with the proceedings of the court. Please, I'm on my feet. I'm on my feet. My Lord, I submit that the witness has been recorded, or the counsel has been recorded as wanting to tender the document. We have been recorded as making a submission in objection thereto. The next thing, they cannot wipe away that proceedings by applying to withdraw it. My Lord, the ruling must follow.
Counsel. You have already responded to the objection to the document. I may record you, read what you say. We have issued a notice to produce. The document was pleaded. That is what you said. Response to the objection. So at that stage, the document cannot be withdrawn against it.
You can't appropriate and appropriate.
It is for me to rule on it.
As the court.
Yes, this is the ruling of the court. I've listened to counsel for the claimant object to the admissibility of the confidentiality agreement. His contention is that what is sought to be tendered is a secondary evidence, and no foundation was laid for its admissibility. The defendant counsel has argued that the document is pleaded and is relevant. And that notice was to produce was given. I recall that in the course of the proceedings, the witness identified the document and admitted that his signature and name is on the document. This document is relevant and was pleaded in several paragraphs of the statement of defense. This document is an important evidence in the resolution of dispute between the parties in this suit. I'm compelled to apply the provisions of Order 5 Rule 6, Sub-Rule 2 of the rules of this court, which allows this court to depart from strict application of the provisions of the Evidence Act as authorized by Section 12 Sub 2B of the NIC Act 2006 in the interest of justice, fairness, equity, and fair play, bearing in mind that by Order 5 Rule 6 Sub 3, the court is enjoined to adopt and apply fair, flexible procedure and should not allow mere technicalities to be clogged doing justice based on the law, equity, and fairness, while considering the fact of any matter before it. For this reason, this court is minded to admit the confidentiality agreement so as to do justice to the parties in this suit. The document shall be admitted in evidence. It is admitted and marked as Exhibit CW 19. Lenasok, if there is NIC, in NIC, we take in every document. We must see it, no matter how it comes. In fact, it is one of the things we have discussed severally in our meetings. Yes. Yes. We take it in, we must see everything. Because of the nature of employment, we must see everything, so that when we do justice to the parties. Yeah. Yes, Defense Council. Oh, the witness is back. Is there? Yeah.
Please tell the honorable court what your responsibilities were as the HR manager of the
Yeah, as at the time I was the HR
Just a minute, please. Let me record the question.
as the court places.
Yes, what is your answer?
Yeah, I was the HR manager of the defendant for about 3 months when I joined them. Thereafter, I became head of HR and administration.
Do you recall your responsibilities?
Hold on. You said you later became the head of human resources?
And administration, sir.
Yes.
Do you recall what your responsibilities were? Your role.
In which role?
As head of human resources.
Oh, okay.
Also, let me give you an advice. I hope you have compressed your question. Don't think you are going to be able to ask all the questions you brought from home. You have 40 minutes to ask this question. Because we are on Zoom meeting, I will do a little extension of that time for you. Because I see that you must flow with the cross-examination. You won't have all the time. Ask all the questions you brought from the office. Yes. Yes, madam, what is your answer?
Okay, as the head of human resources and administration of the defendant, I was in charge of human resources function, which includes recruitment, management of staff, and administration as well, which include office management and all the administration function, including expatriate quota and benefits, to the best of my knowledge, what I can remember.
I've recorded you up to the point that I was in charge of recruitment and management of staff. Yes, what other thing?
And administration, general administration.
Yes, including
Include
arrangement for expatriate quota,
expatriate
safety.
quota, yeah. Employee benefits.
I think that's good.
Okay.
Yes.
You people be one about your management of defender. Because of employment.
He said, do you recall?
One about performance.
I can't remember. I didn't get your question.
Do you recall
Yes, repeat it.
do you recall being warned about your underperformance whilst you were in the employment of the defender?
No.
Yes, counsel.
Do you recall being invited to a meeting on 6th of November 2007 to discuss your performance?
No.
On when? What date did you say? Yes.
Is it your evidence that you were not in a meeting with the managing director of management of the defendant to discuss your performance? That's your evidence.
Yes. I had a meeting with the managing director on that
Sorry,
same,
let me
but
record the
not
question first. Let me record the questions
okay.
first.
Okay.
Yeah, you said you were in the meeting.
I was not in a meeting for the discussion of my performance on that day. On 6th of November 2007, I was in a meeting with the managing director to discuss expatriate quota of the company, which was a meeting attended by the finance director and myself. And the minutes is before this honorable court as one of my evidence.
Yes, counsel.
Yeah.
As an employee of the defendant, having signed the confidentiality agreement, are you aware that you ought not to disclose confidential information regarding the defendant or information? I'm just looking for my right.
Yes.
Information which you acquired in the course of your employment. Are you aware that you are barred from disclosing such information to third parties?
The third party that you're talking about does not include law enforcement agency.
Right, but you cannot answer my question.
No, I'm not aware.
Witness, do you understand the question?
Yes.
The question is, having signed the confidential agreement, you were not to disclose any confidential information acquired in the course of your employment to any third party.
Yes, Your Honor. I'm aware of that, but that third party in my profession exclude law enforcement agency. If there's an infraction about the laws of Nigeria.
Yes.
So you confirm that you divulged confidential information about the information.
You have not confirmed that.
I did not say that.
You didn't say that. Let me read what he said. He said, yes, I am aware of that, but that third party excludes law enforcement agents carrying out their duties that relates to infraction of any laws of Nigeria.
Yes.
What is it?
Did you divulge confidential information? Yes.
I divulge confidential information that has to do with infraction against Nigerian law to law enforcement agency.
No, listen. This is because we don't expect him to answer what you want to hear.
Exactly.
He must answer the way he wants to answer the question. Did you divulge? Yes. Yes.
No, you recall having another meeting on the 9th of November 2000, when you were told that the services were no longer required.
No.
When you told your services were no longer required.
No.
Do you recall having another meeting on the what date? Council?
So November 2003.
2000 and 2000 and what?
2007.
Yes. What is the meeting for? Do you recall having another meeting on the 9th of November 2007?
When you were told that your services were no longer required.
No.
Was there any point when the defendants asked you to resign because the services were no longer required?
No. The defendant did not ask me to resign because my services were no longer required, but the defendant managing director asked for my resignation after
Hold
the
on.
meeting. Okay.
Witness, let me take it slowly. Let me.
Okay, sir.
Your question is, was there at any point the defendant asked you to resign?
Yes, my lord, and she said no.
No. Yes, because your services were no longer required. And the answer is no.
Yeah.
What is your answer?
No, the defendant did not ask me to resign because my services were no longer required.
Yes, counsel.
I want you to think about this carefully. Did you at any time tell the defendant that you needed time to think about the meeting of 9th of November as to whether or not to resign? Do you remember having that conversation?
I just told you there was no meeting on the 9th of November. So what is there to think about? There was no meeting between me and the defendant on the 9th of November.
Sorry, I didn't hear what you said.
There was no meeting between me and the defendant on 9th of November.
Question. So that the discussion is not taking place.
No, I see that question. You are repetitive. You are repeating the question. He has answered it. I don't have to read. He said, no, the defendant did not ask me to resign because my services were no longer required.
I asked the question differently. I said, did you ask the defendant to take time to resign? Time to think about it. Because the proposal was made, I'm asking her to resign. And I'm asking her, did she at any point ask for time to think about it? That was my question, man.
Did you at any time request the defendant to give you time to think about what?
About the proposal to return.
What is your answer, witness?
Okay. There was never a proposal, neither was there a meeting concerning resignation between me and the defendant.
Yes.
But before receiving a letter dated 14th December 2007, terminating your contract of employment.
What's your question?
Dated
14th November 2007.
witness, what is your answer?
I didn't get the question, sir.
He said you received a letter dated 14th day of November 2007 terminating your employment.
Yes, I did. I received that letter on 15th November 2007 in my house.
Yes, counsel.
Can you confirm the last day you sat as an employee in the office of the defendant? If you remember the date.
I think I was
Hold on.
okay.
Yes, witness.
Yeah, I was in the defendant's office up till Thursday, 8th of November 2007. And on the second day, I was denied entrance by the defendant, which was 9th of November.
Yes.
Subsequent to the 9th of November 2007, you were still managing yourself as the HR head of the defendant.
Said what?
Subsequent to the 9th of November.
But we should, this question, I don't understand it. He has already said he was in the office up to the 8th, that from 9 he was denied access. And your letter of determination was served on him on the 15th, dated 14th.
On the 14th day of November 2007, you offered a letter complaining of the defendant denying you access into the premises.
Yes, I sent that letter out to the defendant's superior. in the headquarters.
Just hold on, witness.
Okay, sir.
The question is on the 14th day of November 2007, you complained in writing about your being denied access to the defendant's office.
Yes, I did. I did in the morning of 14th of November.
Yes, counsel.
Do you remember placing this complaint on the defendant's letterhead?
I can't remember using the letterhead because I didn't have access to the letterhead of the defendant.
Don't have I'm sorry, just have time so yes.
Yes.
That letter was written by you.
Yeah, that letter was written using the online access that I have to the defendant's system. It wasn't the physical letterhead.
Yes. Can you wrap it up?
I know that I'm doing my best. I have a contract in myself, so
But you are not. It's not your counter claim now. That is that. Are you doing the defense and the at the same time?
I'll definitely reach my contract.
It's not open ended. The timing is not open ended.
There's no more time. I can't happen.
No. That is not going to be possible. This is the second day we are taking this witness. I don't do that. It's just because of the facility in which we were using to take the witness.
Is it correct for me to say that after your employment was terminated, you still paraded yourself as an employee of Central Park of Stamina?
It depends on what you mean by when the employment was terminated, because it's the subject of this matter.
Hold on, let me finish.
Okay.
Yes.
Okay. The termination date is subject of this matter. So my termination take effect from the date I was signed, the termination letter, which was 15th of November 2007.
Slowly. Yes. Right.
Yes, I said my termination takes effect on the date I was served the termination letter,
Yes.
which was 15th November 2007.
Yes.
I didn't ask you about this termination. I asked you whether it is true or false that you still paraded yourself as an employee of the defendant after your contract of employment had been terminated.
No,
You did not.
I did not.
Yes, counsel.
Contract of employment was terminated. Did you return the defendant property that was in your possession? Laptop, official stationery, handset. Did you return them?
I did not have that opportunity because I was locked out.
Yes, I want to, after the termination of employment, did you return the laptop or other company property positions? What is your answer?
I did not have the opportunity to do so because I was locked out from the defendant's office.
Yes, counsel.
Attempt to return the confidential property and all the property of the defendant after the 14th of November. Did you make any attempt to return?
My employment was not terminated on 14th of November. I was still an employee on 14th of November.
Let me record you before, record the answer, my question before you speak.
Oh, sorry. I'm sorry, sir.
Yes, what is your answer?
I was still an employee on the 14th of November.
I said after the 14th of November.
After the 14th of November.
What was the question?
I said, did you make any attempt to return the company properties after the 14th of November 2007?
Yes, I did. The defender gave instruction to the security guard not to let me in to the company.
Yes, Counsel, I will allow you to ask 3 questions.
Can you tell the Honorable Court the date on which you were denied entry after the 14th day of November 2020?
On
You
the
just said
15th,
attempted and you were denied.
Hold on, witness. Listen to the question. Hold on.
On what day was that?
What is your answer?
on the 15th of November and also on the 16th.
Yes, Counsel.
So that I don't need time, I will quickly go to the next question. Do you recall being given a loan while you were in employment of the defendant?
Do I what?
What's your answer?
I didn't get the question, sir.
It said, were you given a loan while in employment of the defendant?
No.
Yes, that's your last question you are going to ask now.
I need to ask you one more time. Is it your evidence that you were not indebted to the defendant and that the date of contract of employment was terminated? That's your evidence.
Yes. That's my evidence.
Yes. So can you re-examination? This is the case of the claimant. I hope the witness, we are not taking him on Zoom again.
I'm sorry.
Is he going to be a Zoom witness?
My Lord, that witness is listening.
Fine. You'll be able to bring him, yes. So I will give you a date for further hearing.
Yes, for confirmation.
Yes. What date?
Fourth of June. My Lord, I'm still looking for cement conveying. Most of
This matter is adjourned to the 4th day of June 2025 for continuation of hearing.
we have very clear.